If you have any comments for public comment, just in general, we have this color-coded system. We have a yellow one, so if you would fill that out and give it to Lucy as well. But only if you're here for the public hearing. That's if you have testimony for the public hearing, but if you have no testimony, you don't need to fill it out. Okay, all righty. So I think we're ready to begin. Good morning. Welcome, everybody. At this time, we'll open the formal session of the Yamhill County Board of Commissioners for July 28th, 2016, 10 a.m. in room 32 of the courthouse. Jerry, would you lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This is the time we have set aside for invocation. And joining us this morning is the pastor of Valley Baptist Church in McMinnville, Pastor Ronna Cooksey. Pastor has been in a variety of different roles in Texas and here. He's also worked as a missionary in Japan for 10 years. He has 8 children, ages 5 to 23, is married to Kathy, and is now the senior pastor of Valley Baptist. Pastor Cooksey, would you lead us in an invocation, please?
Let's pray. Father in heaven, thank you so much for today, this opportunity to come to you. Thank you for our county and for our commissioners and the rest of the staff that are here and working to serve the rest of us. I pray you bless them with wisdom, with good decision-making, with health. Bless them for serving the rest of us. We do pray for the rest of our community as well. Pray for our police and our sheriff's department and fire department and those who serve us, that you protect them and you bless them and you make things go well for them as they seek to help us. Pray for families in our county that you would heal and strengthen, bless marriages, and that children would be protected, healthy, grow, and have your care over them. Pray for our businesses to thrive and to do well in this time. Pray for our churches to be strong, that our churches could serve the community, could help those in need, and could be faithful to deliver the message of what really gives transformation in life, what really gives life its meaning, the message of Christ Jesus, his death on the cross for us. Lord, I pray for this particular meeting today, and I do pray for wisdom, for direction in every matter, big and small, for cordiality, and for the ability to problem solve together. And we do ask you that you would send a blessing to this county. We pray in Jesus' name. Amen.
Thank you, Pastor. Appreciate you coming. Thank you so much. I just want to acknowledge we have our planning director is retiring, and he's been a phenomenal leader in this county for decades, and he's just, I guess there's no way we can do this officially, but make it to Mike Brante. I know you're trying to dress like
I was told to do the Hawaiian shirt thing, but I guess that other commissioners bailed on me.
Well, anyway, we want to thank him, and also a great appreciation for Ken Friday, who will be taking over the leadership, and appreciate all your wisdom.
I would recommend that you call him over and ask him.
And embarrass him?
And embarrass him?
Well, yeah, sure, but acknowledge what's going on. I know he doesn't want that, but
He really
I was just
doesn't
in a meeting with him, and he said, you know, if things get tough, call me over, and I think they're getting kind of tough.
Yeah, all right. Anyway, yeah, we do appreciate Mike Brandt and Ken Friday as well. Well, this is the time we have set aside for public comment. It's a 30-minute time period reserved for public comment on any topic other than quasi-judicial land use matter or another topic scheduled for public hearing. Unless extended or restricted by the chair or majority of the board, public comment will be limited to 3 minutes per person. We have one person here. Is Rick? I'm sorry, I can't read your...
No, my handwriting's terrible.
Is it Rogers? Okay, that was Laura's best guess. So.
Right.
Okay, thanks, Rick.
Thank
One
you.
for me.
Appreciate your coming. Thank you.
Good morning, commissioners, county staff. My name's Rick Rogers. I'm the executive director of the Habitat for Humanity affiliate that covers Newburgh and surrounding areas. So I'm actually here not with a comment, but with an invitation. You all may have received an email recently And if you haven't, I've got an email. We're having an elected officials build day, August 27th. We've done this a few times in the past, and we would love to have you come out and swing a hammer with us at one of our build sites in Newburgh. So again, it's August 27th from 9 to 4. And I think we'll start at 929 South Blaine, which is a property that actually the city of Newburgh donated the property to us. And we're finishing 3 homes on that site. Alternatively, we may be at our new Restore site, which is on Meridian in Newburgh. And either way, I guarantee you will have a great time swinging a hammer. So there you are. And I'll hand you out the flyers and my card.
Thank you. You know that Commissioner Springer is a builder and developer by trade. So actually, if he comes and swings a hammer, you will know that hammer has been swung.
There we go.
I'm old enough to know a few things, but I'm far too old to perform them. That's
Well, aren't we all, right? Aren't we all,
You
yeah.
finally know some stuff and you're too old.
Councilor Springer and the rest, you are certainly welcome anytime. And you don't have to hold it to an elected officials build day. You can come anytime. In fact, county staff, you all are welcome anytime too. Thursdays, Saturdays, we build, so anytime, okay? Thank you very much, appreciate it.
Thank you so much, Rick. Appreciate it. All right, we'll move on to agenda item B, which is the consent agenda. Entertain a motion to approve the consent agenda.
Madam Chair, I would so move.
All right, we have a motion to approve the consent agenda. All those in favor signify by saying aye.
Aye.
Passes unanimously. Item C, old business, we have none. Other business, do we have the add-on for,
Yes, it's under item D.
under item D? Okay, and item D, other business.
This is Mike's contract.
This is Mike's
Letter.
contract, which is a letter of agreement. So entertain a motion to approve, accept the letter of agreement for the contract for Mike Brandt going forward.
Was that what you were discussing with with Mike?
No.
Oh.
No, I was just asking some other questions, but, so I would move approval of D1, which is in consideration to approve a contract, agreement between Yamhill County and Mike Brandt to provide professional services not to exceed 80 hours a month, effective August 1, 2016 through June 30th, 2017.
Okay, we have a motion to approve item D1. Any further discussion? All those in favor signify by saying aye.
Aye.
Motion passes. On to public hearing. This time we'll open the public hearing, docket C-05-16/SDR-03-16KF. This is an appeal by Chehalem Park and Recreation District, CPRD, of the Planning Director's conditions of approval for a day-use park on approximately 325 acres located on Parrot Mountain. Any abstentions by the board?
No.
Any objections to jurisdiction? Mr. Sadler, would you read the statement required by ORS 197-7635?
I will. Oregon law requires that persons who attend a land use hearing be advised of certain rights and duties before the hearing begins. First, the approval criteria. The law requires the county to list the applicable county and state zoning criteria. A county planner, Ken Friday, will do that in a few minutes. The law requires us to identify those standards that an applicant must satisfy in order for the county to approve an application. Each of the standards must be supported by substantial evidence in the record. Please direct your testimony, claims, or evidence toward the criteria stated by the planner or any other criteria that you believe applies to the application. Second, the raise it or waive it rule. The law says that any issue that might be raised in an appeal of the decision after this hearing must be raised before the record of this hearing is closed. If you do not raise the issue before the record is closed, you cannot raise the issue on appeal. Failure to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the county to respond precludes any action for damages in circuit court. You must identify the issue clearly enough so that the county and all parties have an opportunity to respond to the issue. And finally, the right to have the record remain open. This is the initial hearing. The law grants a participant the right upon proper request to have the record of this hearing remain open for at least 7 days by a participant, which is anybody who's submitting oral or written testimony regarding the application. You may make that request anytime during the hearing, but definitely prior to the time the chair announces that the hearing is closed. Once the hearing is closed, there is no longer a legal right to have the record remain open for additional evidence. Madam Chair?
Thank you, Counselor. I do want to state for the record that this application involves a property on Parrot Mountain. I live on Parrot Mountain, but I feel that I can rule objectively and make a decision based on the information at hand. Mr. Friday, can we have a staff report?
Yes. The entire tract is made up of approximately 325 acres with 9 tax lots ranging in size between 1 to 80 acres. Access is provided by Parrot Mountain Road, and I should point out that the property is outlined in the 2 maps behind me. The entire tract is zoned EF40, exclusive farm use. The property consists mostly of open fields interspersed with trees. 2 of the tax lots contain single-family residences and outbuildings. Neighboring properties are in similar farm uses to that of the subject property. They're also zoned EF40 exclusive farm use with some AF40 and AF20 agricultural forest use interspersed throughout. The tract is also abutting Clackamas County, and lands that are zoned by Clackamas County are EF10 exclusive farm use and TBR Timber District. The request is for a day-use park. Part of the reason for this request was due to events being held on the property during last summer. The weddings and celebratory events hosted on the property would sometimes go late into the evening, and we received a couple of complaints about this. So as part of this request, the applicant is scaling back the available hours for such activities. The applicant expects up to 200 people might attend events in and around the outbuildings and home site located at 10500 Parrot Mountain Road. They are also proposing a 10 p.m. cutoff for all amplified music or voice. The appeal is based on 3 conditions that were placed on the approval. Condition number 5 required fencing between the park and an adjacent vineyard, and it states, prior to use of the park, a fence or other property line delineation acceptable to the owner of tax lot 3325-100 shall be erected along the property line. And then conditions 7 and 8 relate to amplified music and sound, and they state the outdoor amplification of music and sound is not allowed. On-site events and the indoor amplification of music or sound shall end by 10 p.m. And then condition 8 is on-site events having either indoor amplified music or sound or scheduled to go past 9 p.m. shall have CPRD staff person present during the event. The application is subject to section 402.04D, 1101.01, and 1202.02 of the Yamhill County zoning ordinance. I have passed out copies of emails and letters that have been submitted during the past week, and I've passed those on to you via email, so they're just hard copies. I also would like to submit into the record, I've got 3 letters that I just randomly picked out from last year that are approving wine tasting facilities or wineries, and each of these has a condition that states the use of outdoor amplified music or sound is not permitted, just to show that we do this as kind of a standard condition for those sorts of facilities.
Thank you.
And that ends this portion of the staff report.
Thank you very much. This time we'll have the proponent's case.
Yeah, did you give that information to? Yes, I did. He's got a copy.
Good morning, commissioners and staff.
Good morning.
My name is John Bridges. I'm an attorney here at 515 East First Street. I've got with me Don Clements, who's the superintendent of Yamhill Park and Recreation District. This particular piece of property has had 2 successful conditional use permits in the past. And essentially what we've done is we've asked to expand the conditional use permit to allow this park activity. As Mr. Friday indicated, we really only had 3 conditions that we had issues with, and I'll handle the first 2 that are the simplest first, which is condition 5 and 8. So condition 8 simply states that if we're going to have an activity where there's amplified music or there's an event that lasts past 10 o'clock or to 10 o'clock, we need a employee of CPRD present. What we would simply ask is a modification of that condition to require an employee or a agent hired for the purposes of meeting that condition. As you may or may not be aware, CPRD runs on a very lean staffing ratio, and it would probably be the case that they would require a person who's there to hire an agent, and the agent would be the agent of the CPRD, so CPRD could tell them, here are the rules you need to impose, and we don't have a problem with someone being on site to do that. We just don't have the economic capacity to make it an employee. So that's item number 8. Item number 5 requires a fence between, or a demarcation of a line between the park and a neighbor. CPRD has historically been very neighborly and works with people to do just this sort of thing. And we don't really have a problem with that. It just required that we do whatever the neighbor required. And I don't think that that's appropriate. What we would like to do is just have a backup to that and say, or demarcation the parties agree to, and Mr. Clements has talked to that neighbor and he believes we'll be able to reach a consensus on that. But we just wanted to have a backup to item or condition number 5 that said, hey, if we can't reach an agreement, let's put in a standard woven wire fence, which is what I think of as standard farm fencing, about 4-inch square woven wire fencing with T-posts and occasional wood anchoring posts. So that's item 5 and 8. So let me turn kind of to the meat of the issue with regard to some of the comments and neighbor concerns, and that's the issue of sound. As I begin talking about sound, I want you to keep in mind that what we are asking for is a conditional use permit, and I say that because I need you to make sure you keep in mind that this is something that you control on into the future, right? It can be revoked, it can be canceled, or you cannot renew it. And so I say that because my client's going to have a real incentive to make sure that they do what they do all the time, which is, I mean, all of the people around them are their constituency. It's who they serve. So they try to act very neighborly with everybody. But you have an extra kind of tool here that if for some reason they're not doing a good job, you can control that conditional use permit going forward. It's not just what you do today, but going forward. I also want you as a kind of an introductory concept, and of course I like it that the county staff is trying to be consistent with how they treat these vineyards. I mean, we are not a private business, right? So that's one distinction. We are a public entity. We're a quasi-governmental agency. We have people who are voted to be the board that controls our organization. So similar to you, elected officials. So I think you can identify a reason that you're going to treat us differently than you treated these wineries. But I also want you to be aware that that condition, just in and of itself, is problematic in today's day and age. Because we have, as you've seen, a very large segment, which makes it a beautiful park. It's going to be fantastic for trails, horseback riding, biking, picnicking, all kinds of activities. But at the same time, you got to keep in mind today's technology. And that condition could mean that you revoke our conditional use permit because somebody, not us, not a registered formal activity, is out there using amplified sound. They might be having a picnic, and believe it or not, this is a speaker I got on Monday as a gift at a Providence Health Foundation golf tournament. And I could set it up, it's all Bluetooth, and I could play my music there. But theoretically, with this condition, if someone's in the far corner, not anywhere near where we want to have potential events, they could be set up with something like this, as easy as this, and we could be deemed in violation of this condition. And so as you can imagine, that would be a policing nightmare. And trying to make sure that nobody's doing that in a park setting on 325 acres is just economically infeasible. But let me talk to you about some information I provided in my application. And, you know, what you can do is you can compare what we're asking to do to what already is allowed out in this area. And I compared it to farming activity. You know, if you're combining, what's the noise involved in that? If you're running a chainsaw, what's the noise involved in that? If you're, you know, running a hay baler, what's the noise involved in that? If any of these neighbors in and around here wanted to have a private activity, a birthday party with amplified music, if any of them wanted to have a wedding, I've had a wedding on my property. It was a friend of mine, they wanted to get married, and I've only got 5 acres. There's nothing that stops that sort of stuff, and I think Mr. Friday correctly pointed out, you know, when considering another issue, this property could be subdivided into many, many parcels, and you could have tons of wineries up there at whatever the criteria, a number of acres, is planted with grapes. So you can kind of think about the kind of impact those things have and compare that to the impact that we want to have as we register a participant to hold an event there, whether it's a birthday party or maybe their grandmother's turning 100 and they want to have a gathering, or they want to have a family reunion, or any of those sorts of things. So I gave you anecdotal information in my application, and then I read what some of the comments were. And because of the concerns that people raised about noise, we went ahead, the Park District went ahead and hired a company called Michael Miner and Associates. And I'm hopeful that Mr. Friday distributed the report that they did. And it goes in, and you know, if it's the first sound report I've ever hired that done. I had some light studies done, and frankly, I knew that light worked mathematically and under the laws of physics, and I knew sound would do the same thing. And this engineer has tried to make it simplified and explain it to you. But essentially, what he's able to do is if we hold that event at a spot that's kind of centrally located in that bottom rectangle, he can calculate the dissipation of sound as it travels, because it behaves in a mathematical way. And what he's done through this report is demonstrated that sound for a speaker or a musician that's amplified, that's held in the center of that bottom rectangle, will have dissipated or reduced to the level that it is commonplace in this area. And he gave, I think on page 5 of that report, there's a kind of a scale of common sounds, and the sound that he says is going to exist in his most conservative equation, which doesn't consider ground absorption or any of those sorts of things, is between this 40 and 50 location, which 40 is a bedroom or quiet living room, and 50 is a typical quiet office environment. And then 60 is a television, as an example of the sound involved in that. And he's indicated that through his study that he found that he also studied DEQ standards, and because this bounds Clackamas County actually has a noise standard, Yamhill County doesn't. And he compared the noise that would be delivered to that property line on the east there, the right side, because that's where Clackamas County starts. And he found that the noise that would be generated by an event, both with accumulation of cars, music, and other activities, would be below DEQ standard and would be below Clackamas County standard. And I think a good comparison that he gave was that it would actually be less than the ambient noise of rural farming areas. And he cited to you a study that they had done in a rural farming area around the Bend area, and found that this noise from this event would be less than that ambient noise. And I think that that's evidence that we can engage in this activity and not impact the surrounding properties more, or certainly not significantly more, but even, I don't even think more than what is occurring there naturally with the other homeowners of there. And certainly not more than what could occur if we were farming that all, or we subdivided it and it made a bunch of wineries out of it. You compare those sorts of things, we're gonna have an impact that's far, far, far less than that. So I think that there's significant evidence in the record with this sound study that we are not gonna have those impacts, and you could allow us a condition 7 that said something like the following. On-site, and I toyed with the term formal, but maybe the better term is reserved. On CPRD's website, they have, of the facilities that you can reserve, they have a listing of them. And you have to register and reserve them. And what I'm trying to distinguish is in a thing like this from something that we formally authorize, right? Because we shouldn't be responsible. I mean, we can't police this, honestly. We cannot police on 325 acres somebody pulling out a 1-inch speaker and starting to play music as they have a picnic. But so here's my proposed condition for condition 7. On-site formal/reserved events, including inside or outside amplification of music or sound, shall end by 10 p.m. And that I just have added the outside component to the condition that was already there, and I merely added that formal reserved component to it as well.
Mr. Bridges, can you state that one more time?
Yes. On-site events, or on-site formal/reserved events, comma, including inside or outside amplification of music or sound, shall end by 10 p.m. And then it would further be modified by the other condition number 8, which says that there will be a person on site that's a CPRD representative to enforce these rules. And I don't think I told you, and I should have gave you a little bit of background. There's essentially, in this central location, there's a house, a barn, and a structure here, so it makes that kind of U-shaped. And there's parking in this area, which is discussed in the staff report. And that's the likely location that these events will occur. And that's where the sound engineer measured the neighboring property that's the closest to it. And we did acknowledge that we would agree to a limitation on the number of participants in that formal or reserved event. I'm happy to answer any questions, and Mr. Clements here as well to answer questions.
Any questions by the board?
You want to hire somebody rather than have personnel that's associated with the Yamhill Parks monitor these events? Is that what I'm understanding?
Yes, we want that option. If we have manpower available, you know, it's like right now, manpower is stretched super thin because we have a softball tournament every weekend at the fields back behind CV, And you've got way more maintenance you have to do in the summertime. Particularly right now, we're super stressed because we're designing and building a new pool complex. So it's just one of those things where we want a backstop, and we don't want to have to tell a person who wants to have an event, no, we can't do it because we can't guarantee we're going to have CPRD. It's less expensive for us to have a CPRD staff person there than it is for a hired person. And mind you, I don't think it would be a different hired person each time. It'd be the same one. We'd be using them over and over again.
And what would be the criteria that you would use in determining the qualifications of that person?
One of the things that we do is that, for instance, if the event, say, has 150 people, we would require them to have security. We hire our contract. We've used the Newburgh Police Security. We've hired individual security. We have events all over the district that does that. We have a person who is living at the facility. An example, that particular individual at this time is on vacation. So they're out of the area, so we would have the contract people. The contract people have contacts with not only myself, but Jim and Mark. And if an event or something occurs, they know who to call, and we will respond. So that's the way we work it, and we have those contracts with the individual. It depends on the event and the people, especially if they're going to have alcohol. We want security there. That's kind of been the way we worked on it. For instance, do we fudge a little bit? Probably. Like if the chamber or someone is having wine, we may not require security because like the police chief will be there and those type, we kind of go by individual type situations.
And just for the record, that was Jim McMaster, who is the assistant, superintendent, but he's the second in charge at the Park District, and Mark Martin, who is also an executive in the Park District. So they would have multiple contacts to be able to follow up if there's some sort of problem.
Mr. Clements, have you had neighbors or anyone trying to contact you in the past when there's been an issue? Has there been someone who would pick up the phone or be able to come on site if there's, because I know that even though they were not permitted, there have been events going on up there without this permission. Has there been security there at each event? And have you had someone who would be there, for instance, when the fire occurred? Was there someone was CPRD available in all or any of those instances when there has been an issue in the past?
Yes, there was always, until we get this worked out, we agreed that we've always had staff there, and we'll probably do that. When we have staff there, if there is alcohol involved, we have staff and security. But
I'm sorry, what I'm asking is, has there been a staff person who has been a person of contact when there has been an issue in the past, and has there been security at every venue that you have had in the past, in the evenings?
And so let me just clarify, you're talking about at this Parrot
Correct.
Mountain location,
Correct.
right? I've spoken with Jim McMaster about that, so I can try to answer a little bit that. There's only been, since the CPRD has owned the property, there's only been, I believe, 3 events. One is a stargazing event, one was a wedding, and I cannot recall what the third one was. And apparently a neighbor attempted to contact somebody and thought nobody was on site, but there was a CPRD staff person on the occasion that they attempted to contact somebody. And I don't know what the issue was with the ability to contact them. I think it might have been a cell phone pickup or drop sort of issue. But there have been staff people there. In fact, the wedding that occurred there was a staff person's wedding.
Okay, I don't know, maybe I'm not making myself clear. In the event of an issue in the past, has someone always been able to be contacted, and have there been issues to the contrary?
Well, I think I just said that I believe a neighbor attempted to contact a CPRD staff person that was on site at an event and had a did not get through. But the staff person was there and did not believe that there was any problem with anything that was occurring on site, and indicated that nobody had attempted to communicate to them.
Recently, there was a fire up there. It was quite significant. There were evacuations. I'm wondering was there the ability to contact somebody at that point to say, we have a situation here?
Well, there are people living in the two residences, and I don't know if they were part of the evacuation. Do you know if they were part of the evacuation? You're talking about in July 2015?
Correct.
One of the things with the sheriff's department as well as with the police department, I've never gotten a call from the sheriff, but I have from the police all the time. They have phone numbers whereby they can contact. As the commissioners were, we had a little situation where I was on vacation and got contacted. We usually respond when that is possible. And we're on all our facilities, we have little plaques with phone numbers. And the same number that you reached me on vacation was on that plaques. And we take that very seriously to be as responsive as we can. We put those phone numbers on those areas. And I get called all the time. I get called sometimes 2 a.m. in the morning with a problem, or at 12. Have I missed a call? Yes. I don't think there's any system that is totally foolproof, but I probably responded to probably 90% of all that come, but occasionally one will be dropped or missed or something like that. But usually, sometimes I'll get a call and they'll leave a voicemail, and then I'll call Jim or Mark or somebody nearby because I may be out of town. I was in Georgia once when Ron Hatfield called, and I called Jim and we were able to respond. So that's our current system. Are we totally 100%? I don't think anyone is, and not including us, but we try to be as responsive as possible.
Thank you. Any further questions?
Yeah, just some kind of gathering this thing up a little bit. The sound study that you've done, in my experience with this, and just as a layman, a lot of it depends on prevailing winds. If I get, and I don't know what happens on Parent Mountain, but I imagine there's some winds, and it probably would affect some of this. And I know that I can hear the fairgrounds from my house. We're a number of miles away if the prevailing winds are coming from the east. And so, there's probably going to be some additional washover at times. I'm thinking of some of these other people that have come for permits for weddings or rodeos or whatever. And we have people contentious with that are, 8 or 10 miles away sometimes. And I think we have to be reasonable. But it was just something that kind of kicked into my head, because I remember if the prevailing winds are a certain way, you can kind of throw this out a little bit because it'll carry that sound significantly farther, I believe.
I don't know that prevailing winds has an impact one way or another on sound. But one thing I would tell you is the engineer utilized what he described as a conservative number, and that's what he's displaying to you. And so what he's actually saying is, hey, these numbers would potentially be lower if I did a ground absorption. In other words, if a sound is occurring right here, one of the things that occurs in physics, so if I'm holding it up in a middle space, it goes in all directions. Now that makes sense, right? What he's talking about in terms of ground absorption is that when it goes across the ground, some of the sound is actually captured by the ground and it reduces it at a greater rate than if it's just air that it's going through. And the same is true of those buildings, the house, the garage, this building that's a kitchen. I mentioned it's a U-shaped area. What he says is he's indicated that he hasn't made a deduction for ground absorption. He hasn't made a deduction for the buildings that are there. He's using a number that's more of a straight line number, so it gives you a data point that is very, very conservative. And that if he went out there, he probably would have a lower number if that was.
And I appreciate that, but there are some physics behind prevailing winds. Unlike light doesn't really affect light to have prevailing winds, but it does with music.
Tunes on Tuesday used to be on the back side. We moved it to the front side, and it has the building there. The neighbors were much more pleased. We also have learned how to turn the speakers to minimize all of the situation, because how those speakers are turned. The other thing, the reason we wanted to do this study is to make sure that, first of all, we are obligated to meet the law. And DEQ has certain situations. We need to make sure that we do that. What can you set a decibel at, and what is the results? And as we go into this, will we do everything perfect to begin with? No. But we'll do everything in our power to mitigate and minimize that noise level to the surrounding areas. That's our intent. That's the reason we had this study done, and we'll probably be working with them to make sure we minimize that to the best of our ability. As you stated, will we do everything perfect? No. But as John stated, you have the ability, if we don't, you have the ability to come back at a later date and wipe us out.
And
Thank you.
I mentioned one other thing, just so you know it. Our park district is involved in a master plan process. They've hired a consultant to help them through that planning process, because it's not something that they do on a regular basis. As a result, they are going out to all of their little communities, and when I say all their little communities, I mean just like this neighborhood. And so in September, they have a series of planned meetings with neighborhoods around the softball fields that are at Chehalem Valley Middle School and the senior center there. And they're going to all the neighborhoods around their different parks to say lots of different things, but to ask lots of questions. One of the questions is, are we doing it right? Is there more you want from us? And so that's something that they're going to do pretty immediately with this neighborhood, because they want to know what the surrounding landowners how they'd like to use the park. But it also would be an ongoing opportunity for neighbors to give them input on saying, geez, that one on August 25th went till 10:15. I heard the music till 10:15 or whatever. And so they'll listen and react, and they'll have opportunities for that.
Thank you.
And I don't see you guys running amok on this, because you've got a lot more attention and ways for you to be leveraged than a private individual. And so I don't see this as, out of hand. But I want to get back to the representative that was recommended on site. And at first it was, we don't have the finances for that. And then I thought I heard later on that there would be a representative on site.
No.
Did I mix up a couple of facts there?
Well, we want the condition to say we always have somebody there during an event, a reserved event.
Right.
And I was modifying the condition to say that it would be a staff person or someone that the park district hired.
Sure.
And so the condition as written, it said it had to be a staff person. And I was just trying to give some flexibility that if we were too taxed in terms of spread too thin, that we could hire somebody. And frankly, in some circumstances, like when they hire the police department to be the on-site people, it's probably more appropriate that it be the police department than it be, a staff person.
One other question, and I'm done. When you take these reservations for a reserved event, will you review their equipment? Meaning, we've got some restrictions here, folks, and we want to know, what kind of equipment are you dragging out to this event? Is that going to be kind of part of maybe the form or some of the discussion that goes on?
I agree. That's where the problem's going to occur. For instance, if you had a band out there, they're going to crank that thing up. That's what it is. If we have in the agreement the decibels or the amount, and what are those, I don't know right now. That's why we're trying to get the experts in to help us so that we can control that and make sure. I can't go out to for instance, if you rented it and go out and your music's too loud and I haven't informed you how to do that music, is that my responsibility? Yes, it's my responsibility to make sure you're aware of what you can do and not do. And we put all of that in our agreements with the individuals. Will they honor it? I would say over the years, most people honor things. They're pretty good. There's occasionally those people that will not. And we take action when they don't. We just go out and shut it off and it's done. I think the neighbors would say, well, that's good, but how do we get it shut off and who do we call? And that's where the information with the plaques and those type things, so if they go out there, because we don't want them to confront individuals because you can wind up with a big problem. So it's going to be communication and working together. It's just like neighbors. We're a neighbor. We need to be a good neighbor. And
So when they reserve this, though, there's supposedly going to be somebody, a representative on site that could pull the plug.
Yes, sir.
Okay, so that kind of takes care of that, and also you can pay for that through the reservation process, right?
Yes, sir.
By a charge to the, okay, I'm done.
Thank you. Any further questions? So now we'll hear from the opponents.
Thank you.
Thank you. Linda Crabtree. Hi, Linda.
My name is Linda Crabtree. I'm the general manager at J.K. Carrier Wines. Our property is the one on the right of the map that's kind of red. You can see our dory soil poking through. And we are also the property that abuts that is asking for a fence. And just at the outset, we want to say I had to put opposed because that was one of the boxes there, but we actually would welcome community use of this property as a park. None of those activities, offend us in any way. We are worried that there are zero limitations on the number and the size and the scope of the events that can happen up there. It's one thing to have a wedding on your 5-acre property once every 5 years. It's another thing to have a wedding every Friday, Saturday, Sunday night, every weekend of the summer, which could easily happen. We're a small winery. We have the small winery allotment with the land use planning where we can have up to 18 events outside of our wine-specific events. To date, we've had one 12-person meeting up there that was not wine-specific. So we are not really using that piece of this. We are a winery, we're not a wedding venue, we're not a meeting place. And so we really haven't made use of that, and we feel like our property is very limited. The county roads cannot, we think of this all the time, people, even my brother Jim, who's the owner and winemaker, he couldn't be here today. It's IPNC week, it's crazy. You know, he had a 50th birthday a couple years ago, and he thought about, let's have a party up here, and then we thought further and thought, no, we're not having a party up here. It's tiny roads, no shoulders, people drinking. It's a bad plan. So we feel like the application, you know, I think you've addressed the issues that were laid out in the conditional, or came back from the design review, the points. We love the fence. A farm fence is great. We weren't asking really for anything more than that, other than to make sure that no horse wandered onto our property and fell in a hole or something and we got sued. So that's great. The noise, you know, no one lives on our property, so no one's there in the evening to hear a band that goes past 10, 15. So we were, in sort of mentioning that, thinking most about our neighbors that do live there and will hear music going beyond, 9 o'clock and amplified. And so we really feel like there hasn't been enough work done. I mean, we as a small winery had to have a traffic study done when we applied for our tasting room. We're only open 2 days a week. We maybe have 10 cars a weekend. We had to do a traffic study. Where is the traffic study with the vehicle trips and all that and the capacity of these roads? If you get weddings with 200 people coming, you're going to have many, many, many cars on curvy Haugen Road. They're just people getting lost. We deal with that, every week of people that are coming to taste that are lost and they're wandering around. So we feel like the number and the scope and the type of events that can be up here has not been well defined enough. And I feel like even the Yamhill Parks, I think they're going to welcome having a backstop to be able to say to people, nope, we only do, one weekend, one wedding a weekend or one family reunion a weekend, and we're already full. And so, they have a means of saying we have a limitation. Wineries are limited. This is completely unlimited. And we would like to see some measure of designating how many events can happen up here, what size is the maximum, that kind of thing.
Thank you. Questions? Next, John Brookfield. Thank you, Linda.
You're welcome.
John Brookfield.
Thank you.
Hi, John.
So first, I would like to actually address a few points with the CPRD.
Could you identify yourself and your address for the record, please?
John Brookfield. I live on Smith Road at 18450, so I'm about a half mile to the northeast of the property.
Thank you.
First couple of comments regarding what the CPRD lawyer and Don mentioned. They talked about the current technology limits, phone uses, little speakers. Clearly, they really can't control that. But as they said, with this conditional use permit, if the problems come up, you guys can have another hearing, discuss it. They could easily say, right, this is not a scheduled event, it was just people that were here. So whether they have the approval now or not, doesn't seem to be relevant for those situations. So you're going to have a hearing regardless if that's an issue. The second thing was they talked about the acoustics report. Unless I misunderstood, this is all calculation. There was no measurements made anywhere. I actually do live to the northeast, which is the prevailing wind direction from the southwest, which is maybe why I hear the noise so loudly. But I actually do have an acoustics background, so I would actually like to see that report. So I don't know if the 7-day additional period is relevant. I haven't been able to see that report. I didn't know about it until just now.
We can keep the record open.
I would at least like to see that and maybe comment on it, since I have that experience.
Are you asking for the record to remain open? Is that what
Sounded like it.
If I could, yeah. Is that possible?
Yes, if you're making that request, it is
Yes.
possible.
Yes, please. So I'd like to see that report and comment if I can.
Oregon law says that if somebody asks, as I've told you ahead of time, to keep the record open for 7 days, that you're obligated to do that, because this is the initial hearing
And
on
you're,
this matter.
and you're asking for a copy of that report, is that correct?
You're asking for an additional copy regarding acoustics?
He has not gotten
just
a copy of the report.
Or a copy of the report that we've been given?
And I can give him a copy
Okay,
at the end of this testimony.
Good.
okay, great.
And hopefully I can get back to you very quickly, not take 7 days, but, and the last comment was, they talked about the wineries and how much noise wineries make. There are several around our area. I would say at most, each one makes maybe once a month, a couple hours of a tractor running during the day, right? It's kind of white noise, you hardly even notice it. It's very different than people yelling and shouting and music blaring. It's a completely different thing. Sorry, those are the 2 comments. Now I'd like to get to what I made before. I'm going to read because I'm extremely nervous and hope I won't miss something. So thank you for giving me the opportunity to address the commission today regarding the appeal of the conditional use. I have provided written statements previously regarding the conditional use change, and I actually had met with, or was at the hearing with the CPRD board a year and a half, 2 years ago, whenever they bought the property, and voiced the same concerns at that time. And I could certainly go on at great length regarding the many concerns I have, which include the limited water, because we are in a state-designated limited water area. The fire danger, which was very apparent last year, because we had that 14-acre fire, which is right between me and that property. The traffic, we live on a single-lane, partly gravel road. Traffic is already, I would say, doubled in the last year compared to what it was before. And littering and other things. But I'm really going to just focus on the noise issue because that's what the actual appeal currently is about. So in the CPRD application, they spend nearly 16 pages showing exhibits and discussing the state's priorities for more open parkland for picnicking, hiking, other outdoor activities. And I'm fully in favor of all those uses within small groups. The application also states, quote, because of the rural location, parkgoers can expect a quiet and tranquil atmosphere as they enjoy their desired activities. To me, it's clear that that statement is completely conflicting with this ability to blast music whenever they want up until 10 p.m. And it's certainly contrary to what they declare the primary purpose, which is a rural park that has a quiet and tranquil atmosphere. There is a lot of speculation made in the application regarding impact to neighbors, both in traffic and noise and everything else. We can all speculate, which I'm sure would result in a wide range of guesses on what might or might not happen. So I'd like to focus on what has specifically already occurred, because in the end, claims and talk and speculation really have no meaning if they're not met, or if they don't match reality. As stated by the CPRD, the park is located in a very quiet rural location, and parkgoers can expect a quiet and tranquil setting.
John, can you speak up just a bit?
Oh, sorry.
Thank
yes. That is certainly what the neighbors want, since that's one of the main reasons why almost everybody that lives in this area moved there. The claims and description of how minimal park events will impact the neighbors sounds great, but they have already proven not to be accurate. My primary example is one that's already been talked to actually many times, the wedding event that was held just last year in late June, I believe. The CPRD was notified multiple times by myself, I know Yamhill Planning and perhaps others, that their conditional use at the time did not allow such events, but that proceeded anyway. In addition, when I heard this event was happening, I actually I requested and then met with Don Clements and Jim McMaster just 2 days before that event to discuss all the many concerns I had. As part of that meeting, they stated that it was CPRD policy that the music be off at 10 p.m. and then stated emphatically that the music would be off at 10, but then added, or at least down really low. And that a CPRD staff person who lives on site, which they also refer to, would make sure the rules were followed. And I was also given a phone number, which I believe was Jim McMaster's cell phone number, to call if there's any issues. So you may interpret however you want the at least down really low comment. But from my observation, if you tell people the music has to be off at 10 or down really low, what they just heard is there's no time limit. That's my speculation. I'll try to stick to the facts otherwise. On the event day a year ago, we weren't home in the afternoon or early evening, so I don't know how loud the music was then. I believe Carol, who's the nearest neighbor, is here. She can probably talk that better. But as we were going to bed, the music and the people shouting and cheering was clearly audible. I called the number provided, which I believe was Jim's number, about 10:15. There was no answer. Left a message. Stated the music was still going and please have it turned off. About a half hour later, when I was still unable to go to sleep because it was so loud, I basically drove to the park, so I wanted to make sure that really was the source of the noise. Called the number again. That was about 10:45. Left another message because there's still no answer. And I actually shot a video of the party. I actually have a video with me. If you actually want to see it, I can give someone the video file. You guys can watch it later. And just a quick note. So in the video, when I'm shooting, I make a comment that the music was supposed to go about 10:45, and it wasn't Israeli 10. It was just the current time was 10:45. And then I went back home after that, and then shortly after 11, the noise was finally down. So I've lived in many different places, mostly urban. Lots of neighbors have had lots of parties. This is the only location I've ever even considered filing a complaint about. Both the previous ownership, because Liz had several parties and weddings, and then this the current ownership. There have been other neighbors around the area that have had parties. I don't know exactly what their context was. There's probably been a dozen or so over the 9 years we've lived here. But the noise from this property at 10:45 was louder than any of the other ones had ever been at any time during the day. And those other ones were always completely quiet by sunset. Like when we went to bed, you never hear anything at all from any neighbors.
What was the date on this one?
On which one?
The one you're talking about? What was the date?
Of the CPRD one or the other?
The one that you're talking about that kept you up and you went and videoed and...
That's June of last year. Yeah, the one we've already talked, other people have already referred to it. June 27th, I think. I don't remember for sure. And actually, in addition, we actually use a white noise maker in our bedroom because otherwise it's so quiet it's actually hard to sleep. So the one thing that has changed over time is there used to be old growth between us and the farmhouse. That's actually all cut down by the previous owners. So if you actually stand at their shop, which is right behind, or barn, which is right kind of behind the area where they have the weddings, you can actually see Smith Road. There's no trees between there other than some really low ones, and it's kind of a dipping road. So there's a straight shot and the wind direction to our area, and there's several other houses there as well. I think I'm very safe in saying that the CPRD and the current management have a wealth of experience in hosting events, and I can only speculate why, in this case, the music couldn't get turned down, even though they told me it would be 2 days before. And I have no doubt that they could strictly follow whatever rules they choose to. But the bottom line is they knowingly were violating Yamhill planning, because they had already told them they couldn't have that event. And they couldn't even follow through with what they told me just 2 days before. Given the amount of impact the events at the park have already had on the local community, I don't see any reason to reward the CPRD with the freedom to make largely unlimited noise, to amplify music and noise, especially when approval is very rarely granted, as Ken confirmed just a little while ago. I did find it a little amusing that the CPRD state in their appeal that, quote, many of these groups will be deterred from hosting their events at the site because of this restriction alone, which is referring to the no-amplified music. And my response to that is great, because those are exactly the people that we don't want there, that all they want to do is come and make a ton of noise and blast out the whole mountain with music and other cheering. So we'd like to also just touching on the other appeal item, which is the staff member being present. At the event a year ago, I think already showed that is not sufficient, because there was someone there, and the music continued until 11. In addition to requiring a staff member or a hired agent, I think either is fine, be present, I think it is reasonable to require that that person be publicly accessible by phone at all times and have the authority to act immediately, of course. And maybe that does happen. Maybe I just wasn't given the correct number, but I think that is a reasonable addition to that requirement. Because when I called, somebody getting a message an hour later just doesn't really cut the mustard. In closing, I would like to say that I believe I understand the motivation for the CPRD requests. This is a very large property. There's lots of work to maintain it, and they can make lots of money with weddings and other events. I could easily see them having, as the previous person pointed out, multiple weddings every month all summer long. However, they do produce a lot of noise, which is very contrary to what I believe is the stated main purpose of the park. Also, I think it's perfectly reasonable that they should show that they can act responsibly when hosting events before being given additional freedom, because I don't think that's occurred thus far. I understand there is a procedure to have special use permits for events, and perhaps after hosting some number of those, there may be a different direction, and they may warrant more freedom. But for now, I believe the bottom line for the commission is really, do you believe all the talk and speculation on whether noise travels or not, or do you believe really what's already been observed in the community? I think those two things are very different. The noise does carry a long way in this area, and it does disturb the community. Thank you.
Thank you, John.
Thank you.
Next, Carol Taylor. Carol, could you state your name and your address for the record, please?
My name is Carol Taylor. I live at 31313 Southwest Heater Road, Sherwood, Oregon. Our back fence line is Yamhill County and the park. And we live in Clackamas County, but we are the direct neighbor of the park. We've lived in our property for 35 years, and this is going to be sort of a colloquial presentation because I don't have documents, but we grew up, our kids grew up with Bob and Crystal Riley, who owned the property behind us. So my question is always, what would Bob and Crystal think when I'm thinking about this park? And I know that they love the park department, and we're thrilled that the park department took over this property because we think it'll be a responsible and good use for the community. But we do have concerns, and I want to show you where we live. We live right about here, and I've been walking up to the farm through the woods and into the woods for the last 30-some years. This all looks like it's farm property, but it's a lot of individuals' properties ranging from 5 3/4 acres to 40 acres to more. And everybody is raising animals or produce or farming or renting out the land to grow different things. But what we all know up here is that there are a lot of houses and a lot of individuals who live here enjoying the tranquility and the ruralness of the area, which is what makes it special for us, and it also makes it special for somebody who wants to get married out there or have a 100-year grandma's birthday party. I'm not so worried about grandma's music as I am about the 20-year-old who wants to go out and, dance the night away. We were really relieved when we heard that the county was going to allow no amplified music, because we have lived through many nights when we couldn't sleep because there was loud music booming up from above. And it's not even so bad when it's just music. There's different kind of music. And then there's karaoke. And then there are the toasts and the cheers and the clapping. And it's not pleasant, and it's not always one person, one family who hears it. We sometimes miss the music because it carries way off down a gulch somewhere else, and people further away are getting blasted out. We've had several occasions that the idea of having someone on site to monitor the music sounds okay, except that I've had two personal occasions when I've tried to contact Jim McMaster's. One, I was walking and I came to the corner park and there was a fire. Somebody had been hanging out and their beer bottles were broken around, and there was a fire, and it was getting bigger and bigger and bigger, and I called and I couldn't get anybody. So I ended up hauling 5-gallon buckets of water to put the fire out. I did get a call 2 days later from Jim, and the fire was over by then. And then we had the fire last summer, the big fire, and it looked like it was going to come to our house, and there were ashes and sparks coming down on our house, and we couldn't contact anyone, and the person who lived there was not home. So it's not always easy to get someone if there's an issue. So
Just a second, this is the second time I've heard this. It's a little confusing to me because if I saw a fire incident, I wouldn't be calling Chehalem. I would be calling 911 and the fire department.
they were called.
Okay. Because
But we
I
couldn't-
don't know what these guys are going to do to fight fire.
No, but the
And
point
what
is,
responsibility that is for them to diminish this fire in some way. I think that is what the firefighters do, so.
yes, but the firefighters were trying to find out if there was any other access through the land, so they could come up to the backside of the fire to put it out. And nobody knew what the road system was there. And so they were trying to contact people who might have a map of the roads in the area.
Boy, they should have that even off of Google Earth. They should have all
Well, it's all-
the information,
it's all-
all their GPS stuff, and,
Well, they should.
okay.
Additionally, I believe that the sound study is something that's lovely to have, but you can prove a lot of things with a lot of words and a lot of measurements, and nobody asked me what it sounded like when somebody had a party up there. And I just think that anecdotal information is probably more reliable than an expert who's paid quite a bit of money to come and do a study when you're trying to make a decision on livability of an area. So that's where I'm coming from, and we're neighbors. We want to be good neighbors. We try to be good neighbors. We just think that a variance is a really good idea on the issue of sound.
Thanks, Carol.
Thank you.
Thank you.
We have no public agency reports, do we, Ken?
There were no additional public agency reports, right?
Okay. Rebuttal at this point? Do we have any rebuttal?
Yes.
And I do have a suggested schedule when you get to that point.
Okay, thank you.
Mr. Friday was just anticipating one of my comments right there. Yeah, if the record remained open, we just want a reply period. And I think that's what he's talking about.
If you'd like, I can read what the suggested schedule would be. The record shall be open till 5 p.m. on August 4th, 7 days, for all parties to submit written testimony or evidence to the planning department at 525 Northeast 4th Street. The record shall then be open till 5 p.m. on August 11th for all parties to submit to the planning department written rebuttal to what was submitted during their first open record period. And then finally, the record shall be open for the applicant only to submit final written argument with no new evidence until 5 p.m. August 18th. At that point, the record shall be closed. And my understanding is Commissioner Sterrett would be out on August 25th, so my suggestion is the board shall then reopen the hearing at 10 a.m. on September 1st.
Ken, I think I am here that day.
Oh,
so-
okay. Then my suggestion would be the board shall reopen the hearing at 10 a.m. on August 25th in room 32 of the Yamhill County Courthouse at the point of staff recommendation.
Thank you. Would it be at?
28th, did you say?
25th.
25th.
Sorry.
Okay. Any additional rebuttal at this point?
I'm sorry, that was August 25th?
Yeah, August 25th would be, and your final written rebuttal would be August 18th.
Yeah. Let me mention a couple of things, and it's
Yeah.
apparent that Mr. Clemens has a couple of items as well. We're talking really on this sound issue about the smallest percentage of how this park is going to be used. The greatest percentage of use, and the vast majority of the time, there will not be events. I would estimate that 95% of the time, it's going to be used by people walking trails, horseback riding, maybe mountain biking or biking, picnicking, no sound amplification. And so what we are trying to do with regard to our conditions is set up some rules that will allow everybody to know what the goalpost is and understand what the Park District can do to utilize this beautiful facility for people who do want to have an event there that would potentially require a reverend to use a microphone so that the people in the audience can hear him as he's doing the service for the wedding. And that's what these conditions would eliminate. It would eliminate that capacity. And I would tell you that I could see if unfortunately, my grandmother didn't live till 100, but if she had a 100th birthday, we would have wanted amplification, because when they were in their lower 90s, they had trouble hearing. So those are the sorts of things that are going to occur here. I think to think of this as being a magnet for a bunch of 20-something-year-olds who want to have a wedding is a bit wrong. The people who are going to be interested in this are going to be interested in it because of its beauty, the outdoor nature of it. The Park District has several other facilities. You know, if someone wants to have a wedding reception and they want to really be able to dance well into the evening, they might choose the Armory if they're a low-budget situation. They might choose the Cultural Center if they have a little bit higher budget. And you guys have been in that room, right? You know where they do that. They do it in the renovated gymnasium, which is a nice little ballroom. And so we have the capacity not only to allow different venues for different circumstances, but we also do have the capacity to control and you know, push people into the appropriate venue. You know, it's the factual information we have, and I don't want to disagree with Mr. Brookfield. We were told that the music was down at 10 o'clock at that event. That's what the staff person on site told us. The beauty of the condition is not that it says the music will be turned down at 10 o'clock. It says that the event is over. And so that's really a great condition, because it's clear that this is not just turn the music off. Party goes on, toasts go on, laughing and whatever. It's that the event's gone, the people are out the door. And that's what we would expect that staff person to enforce. And we'd expect you to have us before you again if we didn't do that on a regular basis, or even semi-regular basis, if we failed in that respect. I would respectfully disagree that this park district has not proven itself over the years. Yes, there are anomalies where things didn't go precisely the way you wanted it to go, but you know, I'm proud to be the lawyer for this park district, because I think they do a fantastic job. And they do it across the whole spectrum of what they do, some of which are events. And our community needs that, you know. As it stands right now, the people who can get married in Newburgh and have a nice facility to do a wedding reception are the people that can afford the Allison. And part of what the Park District tries to do is give them an Armory opportunity, so it's inexpensive. A Chehalem Cultural Center opportunity, so it's a little more expensive, a little nicer facility. Or something of this nature, where it's an outdoor setting. But we need it to be have the components that people will want in that setting, which I clearly think are amplification. I did want to mention, and maybe Don was going to go there as well, and that is that the September 1st is the meeting that's going to be up in this neighborhood, and one of the attendees at that is the fire department, because some of the neighbors had asked for that, because they had wanted to have a plan to deal with some of these issues that have happened in the past, and the fact that it's a 325-acre parcel where yes, there's a caretaker living in one of the houses, but we need to maybe have special rules about how we deal with fire-related and safety-related issues. And so they particularly invited the fire department to participate in that meeting. And so a game plan can be set up. Did you have something further?
Yeah,
on
I did. We've had meetings in the past, and I listened to the neighbors, and the fire was a big issue. I met with Tualatin Valley Fire and Rescue Chief and the Newburgh Chief all in one meeting, and I said, we're going to have this meeting, would you guys come forward? His comment to me, TV and out, was we've been looking for some place for a station or some type of deal up there for a long, long time because water is a big issue. And I said, well, the neighborhood is concerned too. Could we get together? Could you attend this meeting to start the dialogue by which to do that? I do not control them, but they said they would attend the meeting, and it did sound like a good idea. I was further asked, would you guys be willing to provide space and bill? And I said, yes. There has been comments about parking a water truck and those type things up there. And I said, we'd more than work with you. I'm not, again, this is very preliminary. I'm not speaking for them. I'm just giving you my interpretation of the conversation we had with them. And I'm hoping they'll be there September 1 by which to address this issue. And this issue was brought up by the neighbors, and I understand that. And as a member of that neighborhood, I have as much responsibility as they do. Therefore, I wanted to make sure that we stepped up and tried to do that.
Are you a member of that neighborhood? Do you live there?
No,
Yeah,
no,
the
I'm
owns
talking,
the property.
Oh, the
well, I'm
property.
talking about the park
The
district.
park itself?
Right.
Okay.
We wanted to make sure that we acted as a good neighbor, and that's why we wanted to see if this fire issue, the commissioners may be aware or not aware, there was a major fire up there. They did use our facility as a staging area and stuff for that major fire, and they liked that. And so we continued. We made that available when that fire occurred. When the fire occurred, I was out of town, but we had communications by phone and stuff and was able to meet all their criteria.
I think everything else we would just defer to the different comment periods that Mr. Friday has outlined, unless there's any questions that you guys have.
Okay, thank you. I have no further questions. I do have a couple of questions for Mr. Friday. Is this appropriate now for me to ask you these?
Yeah, if I don't have the answers, I'll try to find them.
Okay, thank you. I have no more questions. Any questions?
Right, thank you.
No, I had a concern that I've heard more than once, the attempt to get a hold of Jim and that not being a possibility, and that does concern me because that's a number that people are given, and if that's been an issue more than once or twice, then I think that your process maybe needs to be looked into. And I know that the conditional use permit suggests it be a member of CPRD. However, I would think it would probably behoove us to make that a security person who is available and that they have a phone that is readily answerable and that they have authority to pull the plug and that type of thing if in fact we do go. But I was concerned that I heard numerous times phone calls being made and not getting responded to.
Yeah. I certainly think, at least what we've talked about is that the person who's on site would have the authority to manage the situation. It sounds to me like the two times that where this campfire was still burning when somebody had left, and then the more major fire, those were not during some sort of an event, and so, and the gentleman said that he tried to call Jim during the wedding too. But certainly, I think it's reasonable to say that not only is the person on site responsible and capable and has the authority to make decisions about changing what's happening there, but I think it's reasonable to say that during these events, that a backup person is readily available by phone. And I certainly think we can make that, we can do it during events. We can't do it 24 hours a day.
And that's not an expectation. However, you do have a person living on site, and I'm assuming that that's the purpose, so that there is somebody watching over. And I think that that person, there should be some kind of a schedule, so when they are not going to be at home, that there is an alternate number. But, those are things that we can discuss. They were concerns I had as I listened to the testimony.
We appreciate you letting us know about that.
And should Jim have responded sooner, the answer to that is yes. But also, when we met, my card was given out and my number was not called.
Okay.
There is no guarantee that any one staff member is all available 24 hours. It's not going to happen. That's why we specifically, all supervisors, which involve myself, Jim, Mark, Brendan, and Casey. Those are the people. We provide cell phones. Those are the people. And that's the police department. Go down the list.
Can you just, for the
Thank
record,
you.
tell us Brandon's last name and Casey's
Oh,
last name?
Brendan Thompson,
And Casey,
Casey Creighton.
and they're the managers of the golf
Right,
course.
they're all supervisors, and we are obligated to respond.
Thank you. Thank you.
Thank you very much.
Ken, I have a couple of questions just about your decision initially. So the planning department's decision to deny this appeal in terms of, let's say specifically the music, why has the planning department historically denied amplified music to wineries or other venues?
Yeah, and it's not that we've denied it. Mr. Bridges was talking about, you couldn't have a minister have amplified, voice. It's just that it would be indoors. And the reason that we've done it to put a condition on saying no outdoor amplified voice or music is simply because of complaints we've received in the past. And, this county has a lot of wineries and a lot of opportunities for outdoor events. We don't want to prohibit those, but we want them to be of a nature that doesn't change the county and doesn't change the county in such a way that it becomes a conflict with neighbors. So we've tried to just limit the outdoor amplified music to be just of the nature of parties or private gatherings, not something that's a commercial venue that could be going on every weekend of the summer.
Would there be a limit on the number of, in other words, if there were, let's say, amplified music or weddings or parties or whatever, is there a limit to how many that the park can have?
We haven't placed that down. I think you could do that as a condition. We've, rather than doing that, we put a limit on the number of people gathered to the event, but we have not placed any limit on the number of events. If you would like to do that, I think that's within your power and authority to do so.
I'm just trying to get a feel for why this condition has historically been, placed on venues, and why you came to the conclusion in the past that it was a good idea to say, okay, we're not going to do amplified music.
Just conflicts, just neighborhood conflicts. The calls that we would receive related to amplified music, we would get a lot of them in the summer, and we get enough of them with just private events that we didn't want to have the whole county dotted with, little event venues that could have outdoor amplified music that we would be having to police. The county does have a noise ordinance, but it's something that is really enforced by the sheriff's department. It's not enforced by the county planning department or the code enforcement officer. And basically, it's just to limit conflicts. That's what it boils down to.
If I could add to that, the ordinance that the county has, Madam Chair, for the sheriff runs that, and it does not mention the DEQ standards. It's not subject to the DEQ standards. The DEQ standards don't apply because we have not adopted an ordinance that says that they do. And because of that, we don't really have any effective limits on the level of amplification of a PA system or the level of amplification of a band. And if there's no condition that says something about that, then there is nothing to enforce if you get complaints. There's no way for us to step in and enforce a condition if there's no condition there that specifies what the limitation is. And that's, I think, the reason that the conflicts, anticipating those conflicts, that the county has not been allowing it to date.
It'd be kind of interesting, and I don't know legally where this lands, but kind of interesting if there was a self-limiting structure in place that said, with you guys coming forward, said we've done a study and this is the acceptable decibels. And I'm just even thinking technologically, why we couldn't have a decibel meter out there with a breaker system, and if it goes over, the thing's shut down and you know immediately you've gone over the decibels. So in order to reset the breaker, you realize that you've got to tone it down a little bit. I think there's a way to do that. The other thing is we have the wineries and we have all kinds of events and rodeos and different things, people coming for amplification. I understand why we don't just carte blanche give those out. But to me, a public park is a little different situation. It's not a business, and it does serve the greater public. And we're always looking for parks and places to do, activities. So I would be, if I were you guys and coming with something like that, I would look at this whole decibel thing that you've presented and come up with something that would potentially allow amplified music to a certain extent, so we don't have unmeasured sound going out and people making, comments that may be over the top. We don't know yet because we don't have a measurement system, but I'm sure there's a way to do that, and I'm just thinking that may be another avenue to how to split the baby and get something that works for everybody.
I was talking to Mike Brown, our planning director, and just discussing this, and
sorry, I got a cramp. Get that on film, will you?
It's like, what did I say? Is it something I said?
Well, you got his attention, Mary.
I'm not going to say Mary's a pain in the neck, but right about here. Okay.
Oh, wow.
Continue.
You remember that.
Go ahead. No, I'm going to be up for a while, Charlie.
Okay, all right. Discussing this whole decibel and noise study thing, and he said, when you live in the country, you can hear everything echoes. Someone's talking, you can hear it through a holler, and just that everything is so much more amplified because it is quiet. I've lived up there for 20-something years, and I haven't heard much, except I did hear music one night, and it was pretty loud, but so I'm not sure about decibels. I just know that the practical nature of amplified noise in a country setting, and just for the record, Crystal Parrott Riley, whose grandparents homesteaded the area, was a neighbor and was a real character, and she would come by and talk about what the plans that she had for that, wanted it to be living history. And I think that's where it really would shine, living history. People can come and appreciate the history and old things. So I just appreciate her vision for this, which was living history. Anyway, so I think at this point, we are going to set this over for August 25th. We're going to keep the record open until the 4th, and then a response period till the 11th.
You would be entertaining a motion to do what Ken has asked for.
What if I read this and someone can say so moved?
Yeah.
Okay, that works.
We have to come out of public.
Oh, we have a
Oh, yeah.
question.
Okay. We have a question, can we?
Also, just
Yes?
make a quick comment now.
Is that
Not have to do the whole week thing,
Todd?
so they've had a chance to.
Had you closed the hearing yet?
Oh, actually, we would then move to keep it open, because I forgot to do that.
Okay, sorry.
Okay, so we're going to keep it open as planned. So, Cam, would you?
Yes.
Yes.
The record shall be open until 5 p.m. on August 4th, 2016, for all parties to submit written testimony or evidence to the Planning Department at 525 Northeast 4th Street, McMinnville. The record shall then be open until 5 p.m. on August 11th, 2016, for all parties to submit to the Planning Department written rebuttal to what was submitted during the first open record period. The record shall then be open for the applicant only to submit final written argument with no new evidence until 5 p.m. on August 18th, 2016. At that point, the record shall be closed. The Board of Commissioners shall then reopen the hearing at 10 a.m. on August 25th, 2016, in room 32 of the Yamhill County Courthouse at the point of staff recommendation.
Okay.
Close the public hearing.
Okay,
Not
thank
yet,
you.
no.
No, thank you. All righty. So, close the public hearing?
Well,
Did you have any
Recess. It's a recess because of.
Recess.
Okay, so we'll recess the public hearing and, until August 25th? We need to make a
And-
do we need to vote on the motion?
I move that we follow the schedule just outlined by our planning department for the hearing dates and times, and that the hearing be reopened on the 25th at 10 a.m. for the purpose of a decision being made.
At the point of staff recommendation.
At the point of staff recommendation. Okay, we have a motion on the table. Any further discussion? All those in favor signify by saying aye.
Aye.
The motion passes. So we'll close the public hearing.
Well,
We'll recess.
you did.
We're gonna
Recess.
Recess until the 25th. Let's see, announcements. Do we have any announcements? None? All right, we don't have any announcements, so at this point, we will close the Yamhill County Board of Commissioners formal session. It is 11:37. Thank you all.